The Law Report with Karen Key.
And a very good evening to you from tonight's Law Report program. As you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And just before we begin, a reminder that there's a list of available documents on the Facebook page, Law on SAFM. If you'd like any of those, post a message on Facebook, but please do remember to include your email address. Or if you don't have access to Facebook, you can email me on law@safm.co.za and I can send you a copy of the list and then you can choose what you want. And I'm joined once again this evening by attorney Nicoline Schoeman-Low. She's a director of Schoeman Law Inc., Conveyancers and Notaries Public. Nicoline, welcome back to the show. First time for 2015.
Thank you for having me.
Did you have a nice break?
Yes, just too short, I think.
Yeah, it's always just a little bit too short, but it's nice to have you back, so thank you for joining us again. If you have any questions for us, you can call us now on 0892 10 2010, 0892 10 2010.
Bafana will be no pushovers as they square up against the Black Stars on the 27th of January 2015 on your favorite radio station and in your home of football, SABC 1. Catch this action live from Estadio du Mongomo with kickoff at 8 p.m. SABC Sport, bringing Equatorial Guinea closer to you.
The Law Report with Karen Key.
Right, so before we begin, we're going to be taking some crossings to the Algeria versus South Africa game a bit later in the show, so stay tuned for that. But before we get on to your calls, we do have one or two emails we just need to get through. And the first one is... he says, I wonder if this scenario can be dealt with by one of your family lawyers. He wants to know about maintenance. If you and your wife are married for many years and have 2 adult children, you're the breadwinner providing all the needs of the family. What are the rights of a person who married in community of property and now, after so many years, wants to claim maintenance from you as the husband? Are there certain procedures to follow? And if there are, I will highly appreciate it if you can let me know. Right, so he says not a pleasant one to discuss and it must be treated with care. Yes, it's a bit of an awkward one.
No, of course, and I think regardless of the circumstances that gave rise to the situation at hand, it's always a sensitive matter. Firstly, I think we need to distinguish between a child's maintenance and a spouse's maintenance. Firstly, a child's maintenance payment is due regardless of how you and your spouse were married. It's about the biological connection and your obligation as a parent, a biological parent, to sustain and support your child. So just to make that very clear, child maintenance is a very different topic to spousal maintenance. And from my understanding, this is about spousal maintenance.
Because it mentions adult children, so they're out of the picture.
Presumably, there's no need for a maintenance provision unless one of them may be disabled anyway. So in terms of the spousal maintenance, the courts really do consider a variety of factors when determining whether a spouse really does have a maintenance claim. So these claims are not instituted or granted lightly by our courts. They'll look at things like how old the person is, yes, how long you were married, yes, who was the breadwinner, but also what is the likelihood of this person getting remarried to someone else, what is this person's income generating ability, even if they didn't work during the marriage, but if they maybe hold a qualification of some sort or have experience prior to marriage, then of course the argument could also be that they could very much go back to work and sustain themselves, and therefore the maintenance won't be necessary. So it would really depend on who we're talking about and what the prospects of that person would be.
Now, he mentions married in community of property, so I'm not sure whether they've got divorced at some point. What would be the case if they got divorced, neither of them is working, and they've now split what they had in half? Can the wife still claim from the husband? I mean... Of
course, anyone can institute any claim. The question is really whether it will be successful or not. And the court will measure that claim against a wife, in this instance, ability to sustain herself, potential of getting remarried, and all these things, and what were their standard of living together, and considering the fact that the assets would already have been divided, could she not sustain herself from that division itself? So it's a very complicated scenario.
There's not a cut and dried thing that you can just automatically claim maintenance.
You can claim it, but whether or not it will be
get it.
successful is the other thing. And we need to strike a balance of fairness here. During the marriage, of course, people are willing to contribute. And if there's some factor that precludes the wife or the husband, for that matter, whoever's claiming maintenance against the other, from working and sustaining themselves, and they'll likely not get remarried. Maybe they've been married for so many years that the likelihood just isn't there in terms of age or whatever the case may be.
So you're not really going to be able to give a definitive answer here.
No.
This has to actually be, you have to have some attorneys involved looking at the entire sort of situation, basically.
Yes, I would recommend that this listener goes and seeks legal advice and lays out all the details to the attorney, who would then be able to give a much more clear-cut answer than we've been able to.
Okay, right. Our next email it says, I met Mr. X in 2012. Mr. X had a company which was registered in his name. I was an LLB student when we met, and Mr. X was a dropout of geology at the same university. I advised him to further his studies. The following year, in 2013, he came to stay with me in my rented room while furthering his studies. He proposed that I should market his company, to which I agreed verbally. The conditions of the agreement were that at the time the company got a project, I would be legally registered as a shareholder of the company. We marketed the company and got a sub-tender in 2014. I managed the site alone as a manager for 1 month, and upon my claim of being legally registered as a shareholder, he no longer wanted to do so. In the company profile, he referred to me as a manager, but in our business communications, in emails basically, he referred to me as the managing director. And obviously now nothing's happened. He was promised that he would be a shareholder, and now that he's fulfilled what they verbally agreed to, he's now being sort of pushed aside.
This is a very unfortunate situation, and particularly given a potential friendship that probably existed here. There's a distinction between serving as a manager or a director and a shareholder. And firstly, if you are appointed as a manager or a director, it's like holding employment. And you are entitled to be compensated in terms of the role that you would fulfill. In terms of a shareholder, it's a bit more tricky in that sense to enforce your claim and to demand to become one if there isn't anything in writing selling a portion of the shares, or it becomes he said, she said. So my thoughts would be that being treated like a manager and being able to claim some form of remuneration for your time for the services you've rendered would be much more of a plausible way forward than the claim of the shareholder. Of course, if someone maybe overheard this communication or the verbal exchanges happening, then you could call them as a witness and you could still bring a claim. But the problem is always, if you don't have anything in writing, it becomes a very challenging circumstance to prove and to claim your shares.
So there's pretty much not much unless he has a witness that he can actually do at this point.
Of course, you can still approach court and detail all the communications and the emails. But, if you only have a few emails calling you a manager or managing director, that's a much different role to being a shareholder or a co-owner. So one can always bring it forward and see what the court makes of it, but in lack of better evidence, it would be quite a challenging situation to prove. So unless there's some good witnesses or 1 or 2 emails further substantiating it, I don't think it looks very positive at this point.
That's rather sad, actually.
Yeah.
Right, and I've just been told that most of the calls coming in this evening are for labour law, and that's not tonight. Nicolene doesn't profess to be a labour lawyer.
Unfortunately
not.
No.
And Michael Bagram will be with us, not next week, because next week we're doing property law, and the week after that, the first Monday of every month, Michael Bagram is here. So if you have a labour question, labour-related question, please save it for the first Monday of every month and call in then, because Michael is the expert on labour law, and Nicolene would tell you. If you called in and we asked the question, she would say, please call back when Michael's here, because it's just so much easier. Right, just a reminder, you can call us if you have any questions. We've just got 2 more emails to go, and then we'll take your calls. The number is 0892 10 2010. 0892 10 2010. We'll take the shorter one before we get to the very long one. And it is, the listener says, I bought a laptop, but unfortunately given a wrong one. I came back after 8 days and told that the 7-day period has expired. Now I'm claiming my change because I was given a cheaper one than the amount I've paid, and they're not cooperating. It's now been 3 months. What should I do? But I'm bearing in mind that they gave him the wrong one in the first place.
Well, of course, hopefully this listener's got all the documentation that he, all the complaints and everything that would substantiate all the things that have gone wrong in this transaction, so that he can at least build a proper case and it's not he said, she said, as we mentioned with the previous question. Firstly, this would seem like the laptop was purchased from a dealer of some sorts. I'm not sure if it's online or what the case may be, but in instances where transactions are entered into and the supplier sells a particular product or provides a service of a particular nature in their normal course of business, in other words, it's an ongoing thing, it's not a once-off transaction, then the Consumer Commission would be the place to go. At least it's, as we know, it's like an ombud structure. So any poor consumer service, including something like this where you purchase a specific product and you're given something completely different, you would be able to deal with through there.
And the 7-day thing, is that still part of the thing, or is that changed now with the new Consumer Commission?
The Consumer Protection Act provides for a period of 5 days, which is what we call the cooling off period. So if you've purchased anything, you've got a 5 working day being the keyword period, or business day period, wherein you can return the goods and say, listen, I've changed my mind, I don't want this anymore. Provided, of course, you haven't completely damaged it and all of that. Reasonableness still must still be considered. But the 7 days or 8 days, as the case may be here, that's probably a store arrangement. And in terms of the Consumer Protection Act, all consumers are entitled to a good quality service of what they've requested. So a good quality product and service, if I may just correct myself there. And you've got a period of 6 months which the supplier must guarantee its quality and its durability. So 7 days, 8 days for returns. I think if you refer this to the Consumer Commission, this would probably be turned around in all.
And they've given him another one, but it's a cheaper one than the one he paid for. So I mean, that doesn't sound right either. No,
that doesn't solve the problem. And if it's a case of being out of stock or something like that, then surely there should be some refund of some sorts and not a substitute of a lesser value. The Act is also very clear in that regard. If substitutions are given, then it needs to be at the same quality and at the same level and durability as the consumer had originally signed up to.
Because the listener says it's been 3 months and he still hasn't had any resolution here.
No, then I think sooner rather than later, do report it to the Consumer Commission. Of course, one can always approach the Small Claims Court as well, but the Consumer Commission should also be able to assist. So whichever route, if you want to go the litigious route, there should be an amount below the threshold for the Small Claims Court. Otherwise, the Consumer Commission would be a good alternative.
Great. Just a reminder, if you'd like to ask us a question in a moment, we've got one more email left. The number is 0892 10 2010, 0892 10 2010. And bear in mind that Nicoline's favourite topic to talk about are wills. So if you have anything to know about your will, please give us a call. Right, the next email we got from Craig. It's a very long email and it's all in Afrikaans. And luckily, Nicoline, yes, I mean, I can understand this, but I'm not going to read it all out and try and translate it myself. But basically he bought a car. And it seriously, literally from the first minute, this car, nothing was working on the car.
Yes, it would seem that it's a second-hand bakkie, and that all sorts of things started going wrong, and back and forth between the supplier, and it ends up that the listeners had to spend some money to replace a petrol pump and some tires and all sorts of things over and above the amount that he's paid for the purchase. And he's tried to return the vehicle and get a full refund, but he hasn't been successful in doing so. So, you know, it's not clear from this email whether or not this has been bought through a dealership or if it's been a private deal. All indications to my mind are that it's leaning towards a private deal, and not.
He said
through
a tweedehandse bakkie gekoop, so it's a second-hand bakkie that he bought, and I would imagine that it was a private sale. It sounds to me.
He keeps referring to. But what is a little confusing to me is there's no indication that it's a dealership, but then he refers to a person,
the owner,
being an owner. So let's sketch both scenarios for completeness sake, if nothing else. In the case where this is a private sale, unfortunately, the only recourse would be to claim damages through a court of law. So to go to an attorney, and whichever damages you've suffered, including wanting to return the vehicle and get a full refund, you can then claim through a court structure. Of course, that is quite time consuming.
And it's going to cost him a lot, and possibly more than he spent.
That's what I was going to say. This is probably going to cost more than what the purchase price for this bakkie was. And then the second option, of course, if it wasn't a private deal but a dealership, then of course there are all sorts of regulations and regulatory bodies which could be the listener could go through in order to get a resolution through a more of an ombud structure, such as the Consumer Commission. So in addition to, of course, if he still wants to institute a damages claim, he's welcome to do so, but in addition to that, that's also an option. So at this point in time, I'm quite reluctant to say that given the purchase price, given the amount of money that has been spent, I pick up 1,250 and 2,765 rand.
Plus the price they bought it for was what, 49?
Make it, let's round it up for ease of reference, 50,000. So if we add all of that together, I'm not saying that this is a small amount of money. It is a large amount of money, but legal costs, and trying to launch this on an urgent basis and all of that, particularly with second-hand car salesmen, it's not always possible to actually get any monies from these people. We often refer to them as being men, or it's not intended to be gender specific, but men of straw. In other words, that they've got a business and it looks legitimate, but actually it's an empty shell. So all these risk factors must be considered, and in that sense, maybe an ombud structure would be a better call from a cost perspective.
Okay, so Craig, if you are listening, I did email to tell you that we were going to talk about your question. If you are listening, maybe just drop me an email. Tell me whether it was a private sale or whether it was a dealer. And if it was a dealer, I can then send you contact details of the ombud structure that you could contact, and they could possibly help you. But as Nicolene says, if it's a private sale, the only recourse is to go to court, and that could end up costing you more than what you've spent already.
Just bear in mind that ombud structures do not always have the power to award damages either, because they don't operate like a court of law that can test the authenticity of information in front of it. So, you may in either event not see the recourse you may want. There is often
the possibility, though, that if this is a dealer, there could be a member of the organisation, because there are all these motor federation organisations. There could be a member, and then there could be something that could be done via that. So
yes, of course.
Just let me know if it's a dealer or a private sale.
And if it is a dealer, if it's a reputable one, that we can check all these things, and that would be the best chance.
Right, okay, let's take our first call. Just remember the number to call, 0892 10 20 10. John in Friedenberg, I'm hoping to take your call now, but I see that my studio crew are all on the phone. Just let me see. John, are you with us? No, John isn't with us just yet. John, are you there?
Yes, I'm here.
Oh, there he is. Hello, yes, I can. It's all just a bit go with the soccer tonight. So how can we help you?
Yes, I'm hopeful that your panel can assist me and give me some good advice, as you have the other listeners. Basically, I have approached a law firm in Friedenberg and asked them to become my attorneys of record to register a trust. And then what happened was they agreed, and I assumed that we are in business. But then, a couple of months later, late in last year, in fact, last month, one of the attorneys of the very same firm then opted to represent somebody else against me in another matter. And I was given the assurance that this attorney would not continue his representation of the third party. But then, yes, last week I received a summons from the High Court, and this attorney signed the papers. What can I do? What recourses are there available if attorneys act like that?
Wow, this is quite shocking.
It's a conflict of interest, surely.
This is a very clear conflict of interest. So I would recommend that you take this to the Law Society and report it. And this is most certainly not acceptable that you are instructed as an attorney, whether it's to register a trust, to draft a will, a contract, whatever the instruction may be, and then also to act against that very same client. Even if it's a different attorney to the one you actually saw for purposes of registering this trust. So I would strongly recommend that you institute a complaint at the Law Society.
And be the Law Society of the Northern Provinces?
No,
where are you?
Friedenberg would still be a Cape Law Society.
Oh, it's still the Cape Law Society, okay.
Okay.
Cape Law Society. But don't leave it, John, because it sounds horrendous.
It is horrendous. Look, I got divorced about 5 years ago, and I paid the same lawyer who's now acting against me.
Oh, my.
20,000 rand for a divorce case, which is now, in today's terms, is around about 8,000 if it's contested. Uncontested. But I paid him 20,000 rand, and I received a call from him also in last week, telling me I owe him more money, and this guy would just not leave me. He's asking for money and he's harassing me, and I'm thinking, wow, and your firm, it just does not make sense. I mean, I heard from his partner that he spoke to him, and he inquired whether the attorney that I'm talking about actually contacted me to tell me that he's no longer representing the third party. And I was astonished, and I said, no, he never contacted me about any such thing, but that's a relief, only to receive the papers. And I mean, on top of that, to have somebody, a legal professional at that, almost extort money out of me for a service that was settled out of court. I don't know. I'm baffled as much as you are.
No, definitely. And I think you need to raise all these points, with the account and make sure that you, if they continue requesting more monies, that you get a full statement of account, that you can see how they've previously accounted your payments that you've made and all of that. But it just makes it much worse, seeing that there's a very long history of an engagement with this firm, not just this trust that you've now instructed them to register on your behalf, that there's been a relationship for much longer than that, and they are still acting against you for another party. So most definitely something you must report to the Law Society.
Okay. Thank you so very much for your advice.
Good luck, John.
Excuse me. Thank you very much, and good luck to you guys too, and you're doing great work, and please keep it up.
Thank you so much. Thanks, John. Good night to you. Right, you have any questions for us? The number 0892 10 2010, 0892 10 2010. Marianne in Vanderbijl Park, good evening.
Good evening, Karen. How are you?
I'm very well. How are you?
I'm fine, thanks.
How can we help you tonight?
I'd just like to know, where is the best place to have a will? I have one at the bank at the moment, but lots of people say it takes a long time once I die to settle the will.
Nicolene?
Well, without sounding biased as an attorney, I do agree with the opinion that you've gotten elsewhere, that it's not always the best idea to have a will with a bank or any financial institution for that matter, including insurance brokers, because unfortunately, especially if you don't have a massively large estate, you bluntly put, your estate doesn't get the priority that some of the larger ones may get, and then as a result it takes a really long time to handle everything and to settle it. So I would recommend that you rather go to an attorney who is properly qualified to draft a will. It's a very special document. I mean, it needs to speak for you when you can't speak for yourself. So it can't be vaguely drafted. It can't have sweeping sentences in it. It needs to be very specific, and it needs to be done by someone who does it regularly. And usually most firms give you an original to keep somewhere safe in your house, We, as a firm, tell you to tell someone where you've put it, and then the firm usually also stores it. Some of them charge for it. We, by example, don't. So find a firm that could really assist you in a way that would suit you best.
Do you have a very basic will, Marianne, or is it full of lots of interesting things?
No, it's a basic will. It's just goes to my brothers and sisters, and if they passed away, to my nieces and nephews.
The reason I'm asking you, is this something that Marianne could do during Wills Week?
If it involves minor children, unfortunately not.
No, I'm not married and I have no children. It goes all to my brothers and sisters or my nieces and nephews.
Are the nieces and nephews all over 18?
Yes, they've already got their own children.
Okay, well then fair enough. Then it could be something that could be done during Wills Week, but I'm never comfortable to tell someone to postpone it for 6 months or 8 months, because you never know what can happen. So I always feel much more comfortable if you are interested in updating your will to rather make it a priority.
Okay, and must I have a trustee or anybody to represent the will or something?
You need to have an executor. Which I recommend to personally. My opinion on the matter is to appoint someone like a brother or a sister, someone that you really trust and knew you well, who can always go to an attorney or someone to assist them. I don't believe in appointing an attorney just, for the sake of having an attorney act as an executor. They charge the maximum fee then, and you don't have you don't have as much control over it if it is someone who's close to you.
And if you have your will at the bank then becomes the executor. Am I correct?
Yes.
No, so Marianne, the sooner you maybe get your brother or sister or somebody as the executor and put it with an attorney, is possibly your best bet.
Just remember that the executor must be a local South African for practical reasons.
Yeah, well, it will either be my sister or brother or my niece, because
and they
know me the best.
Fantastic, and we always say have two people, so one in the alternative of the other, and also that as an executor, yes, there's a lot of admin involved, but sometimes you need to make a judgment call on something, for example, to sell something because there's a cash shortfall in the estate, and then you have to pick something.
Yeah.
And if you didn't know the person really well, most of us will pick what will yield the most.
Well, look, the house will have to be sold because I can't leave it. I've got 6 brothers, 6 family members, so I can't leave it to one of them.
No, of course. Now, I always recommend to, if there's a fixed property, to rather sell it. If there's more than 2 owners, I have a personal rule of thumb. It spells trouble.
No, I'm the only owner.
If you leave it to more than 2, even if they get along fabulously during your lifetime, they don't always get along as fabulously after. Not in my experience, but I don't mean to be
disparaging of your family.
I know.
But Marianne, it sounds like you need to go and find an attorney and go and draw up a will and make one of your family members or 2 of them the executors of your estate.
Okay, thanks a lot, and thanks for a very nice program.
It's a pleasure, and good luck to you.
Good luck.
Thanks, Marianne. Good night.
Bye.
Bye-bye. Right, the number to call if you have a question, 0892 10 20 10. Jacques in Cape Town, good evening. Hello, Jacques.
Hi. How are you?
Hi, very well, and you?
Fine, thank you.
How can we help you?
Well, this one's going to be a bit interesting. We had a company together, and we were 4 shareholders in the company a number of years ago. 3 of the company directors fired the 4th one. 4th one retaliated by taking legal action and so forth, and he bypassed the shareholders agreement by going directly to arbitration, and so forth. And but in the end, we appointed a legal representation or representative for us to represent the 3 shareholders. We made payments because there's periodic invoices and bills that have been sent to us, and we made some payments. And due to confusion on their side, they they think, or they thought, so they were under the impression that we did not pay certain invoices, which we proved subsequently we did. But they withdrew, and it led to they withdrew at a very critical time, probably about 2-3 days before our court appearance and so on, leaving us in a very precarious position, leading to, judgments worth millions against us. And we had, we're still fighting to get rid of some of them, because we didn't have ample representation. What do we have any recourse here?
Yeah, of course, by the sounds of it, if you can prove that all those payments were made, then most definitely you can at least. A starting point would be to approach the Law Society and to institute a complaint there against the firm, proving, the invoices and the payments and all the correspondence, attaching all of that to your complaint. So that would be the starting point. And of course, if you say you've lost millions, then I want to say consider taking legal action against this firm. They all have legal insurance. So, it won't be a case of bringing an action and, them turning around saying, oh, sorry, we can't pay. We all must have legal insurance against things like this.
Oh, I see. Okay, so they do have insurance, so it's not a personal liability, because our fear was that there's no way in a month of Sundays this lawyer will come up with this kind of money. In the case of us winning, against him. Yeah. So we thought that, we'd be throwing good money after bad.
No, in terms of only the Law Society's insurance provisions to us, we are covered for just over $1 million per practitioner.
Oh, okay.
So
right.
At least you've got that. And most of us with larger firms have additional insurance.
I see.
So usually it gets diverted to the Fidelity Fund, and they then deal with these claims. So you don't even have to necessarily approach court. You can write a letter to the attorney, report them to the Law Society and to the Fidelity Fund, and in some instances then, if the firm admits liability, then the payment can happen without you actually having to sue them for damages.
I see. Now, when at the time we considered approaching the Law Society, but it seemed that their website or the point of entry for complaints was quite hidden and difficult.
Okay.
And we called around, and then it was basically a members only kind of entry point. There was no recourse or online forms that complaint forms for the public or for any I don't know whether it's changed, but it was very difficult for us to actually access or get into contact with the correct people at the Law Society. There was no official complaint line or something like that.
I don't know. From an attorney's perspective, their website was admittedly quite user unfriendly a couple of years ago. But they have improved that quite a bit. And I know for a fact that anyone that phones them at this point and says, I want to complain against an attorney, whoever picks up the phone is quite willing to put you through to the relevant department and to even fax the forms over to you if you can't download them.
Excellent. Thanks for the good advice. I appreciate it.
All the best.
Have a lovely evening.
Thanks, Jacques. Good luck to you.
Thanks.
Good night. Bye-bye.
Okay,
Is tonight the night of horrendous stories?
It seems like it,
It's like I'm starting to get quite nervous now.
Exactly, and sitting on the opposite side of the table, all I'm hearing is these bad apples really that are really tainting the profession. We're trying to do something good here, not all of us.
No, and I'm just always listening. I only pick the good ones. Right, okay, so let's go to Jean in Durban. Good evening.
Good evening. Thank you for taking the call.
It's a pleasure.
As a trustee of a body corporate, do the trustees have the right to tell an owner to terminate a tenancy on the grounds of consistent non-compliance by the tenant over a period of close to 4 years?
That's always a tricky one. Firstly, I know of many sectional title schemes that have actually amended their conduct rules so that it could make provision for the eviction of another owner's tenant. I haven't read any case where this has been successful. So my advice would be really to write to this owner and to follow your conduct rules. If it allows for fines, keep instituting fines, those kind of things, but really forcing the owner to evict that tenant, that hasn't been proven successfully in any court to my knowledge. So that would be an interesting course of action to take. You won't be able to directly evict the tenant yourself because you are not the owner.
Yes, no, I appreciate
So you'll have to apply to court for either the tenant reinstating certain or making good certain damages that they've caused, or in the alternative, if there's such a nuisance, then of course to move for the eviction. Whether or not that'll be successful, I'm very doubtful. Many people have tried to incorporate it into the conduct rules so that they at least can fine the owner, which eventually forces the owner to evict the tenant because it becomes it becomes a financial strain.
Is the owner sort of playing ball here, Jean, or not really?
No, not really. That's the problem. We have fined the tenant, the owner, on a number of occasions. She's referred the fine to the tenant. They are currently contesting fines, prove it, and in some instances it is quite difficult to prove that the tenant did A at such and such a point in time. And then the other thing, can we go to a lawyer and have a lawyer write a letter and put the legal fees on the owner's account?
Yes. You can most certainly do that if there's a violation of some sort.
Of any kind. So where the tenant has consistently violated, for example, rules relating to parking, and we have attempted unsuccessfully to deal with the issue, can we now just, without consulting the owner further, just go and say, well, we're now going straight to a lawyer?
Well, at most you would be paying the attorney out of pocket if the owner contests the validity of whichever notice you're sending them. But it again depends on what your conduct rules make provision for. I've worked with a number of sectional title schemes that have built in a fine system in addition to a legal recourse system. So we will go through the fines procedure. Some of them even have an appeals procedure against the fines. And if that fails, then we go to an attorney and, then you pick up the tab. And if the owner contests that, then, you end up in arbitration in all likelihood until the Sectional Titles Act has been amended and the Sectional Title Ombud has been created.
Now, the way that the genus is, obviously they're dealing with what they have in their rules. Is there, at any point, can they have a whatever kind of a meeting and change any of those rules or add something to those rules for future? Jean, maybe you should do that.
Yes,
of course, those rules need
at an AGM we can propose.
You can propose the amendments, and that's particularly useful given the fact that the new Act, I don't know how much you know about the new legislation, but the new legislation is causing quite a bit of confusion. So many sectional title schemes are actually advised to revise all their rules in anticipation of these new regulations.
Corinne, I know you give out documentation that would assist.
Yes.
Have you got anything specific
Well,
for us?
next week, Jean, we're doing property law, and Ishmael Mohammed, who's our resident property attorney, this is one of his favorite topics, is sectional title and things like this. So if you want to maybe possibly call in again next week, and you can talk directly to him as well. But I've got your phone number. I'm going to put you back to my producer now, and just give him your email address, Jean, and then I will have a look and see what I've got, and I'll send you what I do have. I do have something on sectional title.
Thank you. And may I ask one more quick
Sure.
question? Where the tenant and the owner constantly come back to the trustees and say, you're racist. We say, don't do this, and we're victimizing and we're racist. Do we have any recourse on that, because it becomes so wearying?
Of course, you can proceed with court action on the basis of defamation of character and things like that, or get an interdict against them to restrain them, as the Americans put it, a restraining order. But all of these things are quite exorbitant in costs. So in many instances, schemes have found it useful to divert that kind of correspondence to the managing agent, who then deals with it. They don't know the people personally, so maybe something more practical is a better solution than proceeding to court, which may be quite costly, in my opinion.
Okay, fine.
Jean, I'll try. I'm going to put you back to the producer now. If you could just give him your email address, and then I will see what I've gotten to send you. But if you want to call in and speak to Ishmael next week, that you can do that as well.
Thanks very much.
Thanks, Jean.
Thank you.
Good night to you. And you're tuned to SAFM, South Africa's news and information leader. I'm Karen Key, and this is the Law Report. My guest tonight is attorney Nicolene Skuman-Low, a director of Skuman Law Inc., Conveyances and Notaries Public, practicing here in Cape Town. And we're doing a law clinic, so no fixed topic. If you have any questions, we just have a few minutes left. You can call us on 0892 10 20 10. Cyril in the Eastern Cape, good evening.
Good evening, Karen. How are you?
I'm fine. How are you?
Okay, I have to say it's the first time I get on to SAFM. Your number is a lot easier this time around.
Oh, well, welcome. Glad to have you on the show.
Thank you. Okay, I'm calling in connection with a friend of mine embezzled my money, or rather stole my money from me. He didn't necessarily steal because I gave it to him like we normally would do business together, but small business. So he got a tender of 167,000 and he was short of 42,000, and he promised to give me 20,000 on top of that. I mean, I think it was 20, in total, but it was some 20-something thousand. You can see I'm not even sure because we never wrote it down.
Cyril, that's not good.
Yeah, I know it's not good at all. So after that, when he got the money, he kept on postponing, I'll pay you. So I could not take him to any court because we never wrote anything down. But then recently he sent me an SMS with a breakdown of everything that we did together. I just wanted to ask, can I use that in courts, just an SMS? Is it good enough? And he's been running away from signing anything. I haven't seen him in ages. This happened last year. Haven't seen him in months.
Well, basically, Cyril, I think if he sends you the SMS with that, that's an admission that he owes you that money, surely.
Yeah, no, most definitely. And I would strongly advise that you now seek legal advice and you try and collect the money through court.
Okay, and will that cost me? Because is there anything I can do not to be charged? Because I actually took money for my school fees that they even set a part of it.
Oh goodness. No, you see, I don't know if there are any attorneys that will work on a contingency fee basis. Many debt collectors do, but be careful of those that you choose. Many of them don't work along ethical lines, and they're not properly registered with the Debt Collectors Association and all these things. So if you are going to go for a debt collector who usually collects the money, and the pay, so to speak, that they get is then taking a portion of the money they collect on your behalf, so they don't actually charge you, that would be the only option for, to get someone to collect the money against no payment of fees.
But they will still charge you partly a commission basis. Almost.
Yeah, it's almost like a commission that they then take. So, but make sure if you do go that route, that you choose someone that is properly registered with the the Debt Collectors Association, and that has a good reputation.
All right. And if I once heard of, I don't know whether it's legal
aid.
Yeah, legal aid. If you own any property, if you earn a salary, anything like that. I believe the threshold is 2,000 Rand a month. If you earn anything more than that, in interest that you earn or anything, property that you rent out, any income that you have, they won't help you, unfortunately.
Sorry. It's legal assist. Yes, I
legal assist, but that's a private company.
That's an insurance company, like Legal Wise.
Yes, you would have had to pay a monthly sort of installment and become a member, and it's over a couple of years or whatever.
Yeah, it's like an insurance
policy. Yeah, that's who they are. But that thing on your SMS, don't delete it, Cyril.
Yeah,
all right,
very important. Print it out if you can.
All right. Thank you very much.
Good luck. Thanks so much for calling. Good night to you.
On the 20th of January, catch the opening Group D matches with Cote d'Ivoire take on Guinea at 6 p.m. and Cameroon tackle Mali at 9 p.m. The next Group D encounters on the 24th of January sees Cote d'Ivoire versus Mali at 6 p.m. and Cameroon versus Guinea at 9 p.m. Finally, to wrap up action in this group on the 28th of January, Cameroon plays Cote d'Ivoire and Guinea battles Mali, with both matches kicking off at 8 p.m. SABC Sport, bringing AFCON 2015 Equatorial Guinea closer to you.
The Law Report with Karen Key.
We have just less than a minute, but before we go, I just wanted to ask you, we mentioned earlier in the program, I mentioned about Wills Week. When is it this year?
It's usually in September, October. So usually some years at the end of September, other years beginning of October. The minute we know, we'll distribute the information.
Okay, because
but we always take part in it, as you know.
As we know, I'm just trying to get people's minds into that mode.
Yeah.
Because when the time comes, there's not that many slots available, and you need to get yourself moving. Because if you haven't had a will before, and we had some wonderful emails last year from people who'd never had a will, or who had taken their workers possibly to go and have a will done, and were so delighted, and which was wonderful. So please bear that in mind again. It's completely free, but it has to be a basic will.
Yes.
Not one with 10 million things in it,
and no
property
updates.
and updates and all that sort of stuff. Basic will, but you need that.
Of
so
course.
It's coming.
And we also have an offering at the firm, which is very reduced at the rate for a basic will. So if you're in a hurry and you need one now before September, October, and you are in Cape Town, that's also on the website.
Great. Well, my thanks once again this evening to Nicoline Skuman-Low. She's a director of Skuman Law Inc., Conveyancers and Notaries Public, practicing here in Cape Town. And she's been my guest on tonight's edition of the Law Report program. We'll be running legal clinics like this one on the second Monday of every month. And Nicoline will be back with us again on Monday, the 9th of February. Nicoline, once again, thank you so much.
Thank you for having me.
The Law Report is on the air on SAFM every Monday evening between 9 and 10. And a reminder, there's a list of available documents on the Facebook page, Law on SAFM. If you'd like any of those, post a message on Facebook. But please do remember, because a lot of you still don't, include your email address. Or if you don't have access to Facebook, email me on law@safm.co.za and I can send you a copy of the list, and then you can choose what you want. I'll be back with you again tomorrow evening just after 9 with Health Matters, so join me then. Stephen Kirk is up now with some nighttime music. Hello, Stephen.